Any update on when mom's coming home?
All right, good morning. Can you hear me? If you can hear me, raise your hand. Never mind. Can you hear me? All right, outstanding. I can't hear you, though. Can you hear me? Is that thing on? Oh, boy.
It is on.
Don't hit it, please. Just put it down.
Can you hear me?
All right, now I can hear you. Now I
Can you hear me now?
I can hear you now.
Oh, okay.
We're going to be selling phones at this rate. All right, good morning, folks. My name is John Fry. I'm a judge here in the... One second.
I don't know if you heard about the construction over in the jail. That was the noise. But if you go ahead with the docket, you probably can beat them because they're working on the air conditioning on the 4th floor.
So we have air conditioning issues on the 4th floor that are going to be noisy in the jail.
Very loud noise in the jail. Right now, they're doing something else, so it's quiet.
Okay.
So you might can beat them.
I might can beat the noise.
You might can beat the noise.
All right, then. Let's see what we can do. All right, folks, good morning. My name's John Fry. I'm a judge here in the 17th Circuit. You're here for a magistrate hearing. A magistrate hearing is your first appearance in court. Obviously, you're aware of the fact you've been charged with a criminal offense. My job right now is to look at the information that's provided as to the basis of your arrest, establish whether or not there is probable cause, then take into consideration a multitude of factors to establish what a reasonable bond is if it is appropriate. If there is a reasonable bond, I take into a number of considerations up to and including your prior criminal history, your flight risk, what you're charged with, and any information that the attorneys will want to provide me. So what's going to happen is I'm going to call your name. When I call your name, you're going to come forward. I'm going to tell you what you're charged with. I'm going to tell you what your monetary bond is. You do have a right to speak to me. You do have a right to look me in the eye through this computer system and tell me what you want to tell me. But I want to caution you. Everything that you're saying is being recorded and will be used against you at a later date. I highly suggest you don't go into the facts of the case because once you've said something, you're bound by what you have said. I will not be stopping you from telling me what you want to tell me. So my favorite scenario, I think the most accurate one, is a person who looks at me and says, Judge Fry, I did not know my license was suspended when the police officer pulled me over. Well, you've just eliminated the defense that it wasn't you. You've just eliminated the defense that you weren't driving. So the only issue becomes whether or not you knew your license was suspended and there's a record of your prior conduct and if you were in court before, you're on video with those charges. At which point your attorney really can't do anything to help you because you've done admitted to everything associated with the case. Again, I will let you speak. You do have a right to speak. I am fully cognizant that each and every one of you is incarcerated against your will. You can speak to me. I just suggest you don't do it. So I'm going to call the roll, or I'm going to call the cases. When I call your case, please come forward as expeditiously as possible. Martinson Lockman. Martinson Lockman.
He's here, President Main Judge.
Mr. Lockman, good morning. You have a no-bond warrant for out of the area, possibly out-of-state felony hold out of the great Commonwealth of Pennsylvania. Do you understand that, sir?
Yes, I do.
Good luck to you, young man. Anna Reshek. Anna Reshek.
She's here, President Judge.
Ma'am, you have a outstanding misdemeanor capias from one of our satellite courts in the amount of $500. Do you understand what you're charged with?
Yes.
Okay, good luck to you, young man. Thank you. Your bond's $500.
Judge, respectfully,
Okay.
and speaking with Mrs. Resesh, she's living in Hollywood. She's been living in the same location for the past 2 years. In speaking to her, she was under the assumption she went to court, I believe, on the 17th to the Hollywood courthouse. And that's when she found out, she was informed that she went on the wrong date. But having said that, Judge, and speaking with Ms. Resesh, she wants to know if Your Honor would consider resolving her case today.
Ma'am, all right, in order to resolve your case, we're going to have to discuss your case. You understand that?
Yes, Your Honor.
You understand? Let me see that paperwork again on her, please. You understand you're charged with 1 count of prostitution, ma'am?
Yes.
And you want to resolve your case today?
Yes, Your Honor.
State what priors are there?
The only prior I saw, Your Honor, was a 2011 DUI.
All right. Anna, you understand if you enter a plea to this, the fine is astronomical. I don't even know what it is. Do we know what it is?
I don't know if this, If I can have one moment, I'll check to see what.
Anna, go ahead and have a
subsection.
seat. I'll consider resolving your case, but it'll be about 45 minutes, okay?
Yes, Your Honor.
All right,
Judge,
thank you, ma'am.
Respectfully, I'm being advised by one of the deputies if we could call the gentleman out of turn.
Sure.
His name is James. He is on page 12 of the doc, so it's in the latter part of your stack of paperwork.
His last
Anthony
name is James?
Correct, Anthony James. No, it's okay.
All right, I'm looking for it.
He's here present, Judge.
All right, Mr. James. All right, Mr. James, you're charged with 1 count of petty theft, 1 count of using a shoplifting control device or countermeasure, 1 count of resisting as far as the theft goes. In addition to that, you have 1, 2, 3, 4, 5 no bond holds. Do you understand that, sir? All right, the court's going to remand you no bond custody of Sheriff of Broward County. You have a VOP on 8/24/17. As to count 1, the petty theft, I'm going to release you on your own recognizance. Count 2, the using and shoplifting control device, I'm going to set your bond at $1,000. Count 3, the combatant theft and resisting recovery of property, I'm going to release you on your own recognizance. You have the violation of probations on 1, 2, 3, 4 separate cases where you're held no bond. Good luck, young man.
Judge, the only request we'd be asking for is would you sign an order allowing this photograph Mr. James' injuries?
Yes, I would. Unique Williams. Unique Williams. Unique Williams.
Mrs. Williams? Oh, wait, one moment, Judge, because they're escorting this other gentleman. They can't have contact, males and females, so it's, they're working it out right now. And, Judge, it's been worked out.
Outstanding. I'm glad to hear that. Good job, BSO. Miss Williams, good morning. You're charged with 1 count of possession of cannabis. 1 count is suspended on license without knowledge. That's a non-criminal infraction. Not wearing your seatbelt, and 2 felony violations. You're remanded custody of Sheriff Broward County. No bond on the felonies. You're released on your own recognizance on the new substantive misdemeanors. Good luck. Shante Santiago.
Ms. Santiago is approaching, Judge.
Thank you. All right, ma'am, I do find probable cause. You're being held on a parole violation. You're also being held on 1 count of robbery with no firearm or weapon. The robbery, no firearm or weapon, your bond's going to be set in the amount of $10,000. Good luck.
Your Honor, we just asked for an order of no victim contact.
We're going to order no victim contact as well.
Thank you.
Judge, respectfully, in speaking with Santiago, she's been residing here in South Florida her whole life. She works at McDonald's. She's been working there for about 2 weeks, making $8 an hour. I do realize she was released from Florida State Prison. However, she's living with her parents, so financially she hasn't built up any sort of financial resources or assets, no money in the bank, no property. The only person that could potentially post her bond is her father, who works in construction. We'd ask you to consider reducing the bond from $10,000 on the robbery charge to $5,000.
Counsel, well stated, well argument. The defendant in this case is on parole from Florida State Prison. She allegedly viciously robbed a human being. She didn't use a weapon. Her bond set at $10,000.
Yes, Judge.
All right, we need to go sidebar for 1 minute, apparently.
And a photo order.
We'll do a photo order on her, too.
Thank you, Judge.
That's her DC number.
Okay, okay, thanks.
Jennifer Davis.
She's still, I think that's still a medical reset.
Oh, why isn't he answering? Stop talking. I know.
Genova Albuquerque.
I'm advised that she should be available tomorrow.
Albuquerque?
That's North Broward.
North Broward. Good morning, North
Yes,
Broward.
but, you have to turn the TV back on, I can't see it.
What are you doing here? You ready?
No, she's a medical reset, but I still can't see it.
You can't see me now?
No, I can't see it.
All right, well, that's okay. I don't look good on video. I have a face for radio. All right, reset Genova Albuquerque. Thank you. Gabrielle Anderson. Gabrielle Anderson.
Your Honor, are you on sidebar? Because we're not streaming.
About the radio thing. All right, Gabrielle Anderson.
Is J-Lo a victim?
You're taking off things out. Sorry to hear that. All right, Gabrielle Anderson.
We're still on sidebar.
I say, North Broward now.
All right, outstanding. Gabrielle Anderson.
Mr. Anderson's here approaching Georgia Main.
All right. Good morning, Mr. Anderson. All right, sir, I do find probable cause as to count one. I'm not going to address the bond as count two. Your bond set in the amount of $100. Good luck, young man.
Judge, Mr. Anderson is requesting if you would consider resolving his case today.
Yeah, I apologize.
All right, Mr. Anderson's priors.
Yes, Judge. Trespass, he pled out February of this year. 2016, resisting without violence and trespass. 2015, 2 counts of trespass. 2015, trespass, disorderly conduct. 2014, 3 separate trespasses, a battery in 2013.
His bond's going to be set at $100. If he wants to resolve it, I'm going to give him 15 days in county jail. He allegedly tried to punch the Kirk. He has an extensive history doing this, and he fought with the police.
Respectfully, Judge, he wishes to decline your offer at this time.
Very good.
Can I resolve? Can I ROR?
No, sir, your bond's going to be $100. You seem to have a propensity for creating mayhem. All right, I need to have a monetary bond. Good luck. Lorenzo McKinney. Lorenzo McKinney.
Mr. McKinney's here at Main, Judge.
Yeah, he said ROR and all counts, all the misdemeanors.
All right, sir, I do find probable cause as to count one. Your bond set in an amount of $100. Good luck, young man.
Judge, I don't see where there's any field testing for the marijuana to be positive in this case.
It's second paragraph, second page.
Field tested
okay,
the green
I got it,
leafy
I got
substance. $100. Thank you, sir. Christopher Francis.
Judge,
Yes.
speaking of Mr. McKinley, right now he just unfortunately quit his job about 2 weeks ago. He was working for a moving company. He's currently right now looking for work. He lives in Dania Beach with his mother.
Does he qualify for pretrial on the misdemeanor?
Only the court orders us to take.
All right, the court orders him to pretrial. Good luck, young man. Christopher
Judge,
Francis.
you wouldn't consider an ROR
No.
considering it's a cannabis offense?
It is a cannabis offense, but there's a whole bunch more to that story. So he can post $100 bond, or in the alternative, and I'm not saying I was there, but I mean, we got police helicopters, we got all kinds of stuff going on this. All right, so $100 or pretrial. Which would he prefer?
Pretrial release, Judge.
Okay.
I'll give him the map.
Pretrial. Good luck, young man. Christopher Francis. Christopher Francis.
Mr. Francis is here present, Judge?
Mr. Francis, you're charged with a misdemeanor capias having to do with your driver's license. Your bond set at $500. Good luck, young man.
Judge, Mr. Francis wants to know if he can resolve his case.
Can I
today
see
for
Mr.
attention.
Francis's driving history? Okay, thank you. Give me 1 second, Counselor.
Yes, Judge.
Looks like this is a first.
Mr. Francis, raise your right hand. You swear, affirm, tell the truth, the whole truth, nothing but the truth.
Yes.
Tell me your full legal name.
Christopher Francis Anthony.
Mr. Francis, you understand this great state of Florida has charged you with a criminal offense. Specifically, you're charged with 1 count of operating without a valid driver's license. Do you understand that?
Yes.
You understand I could punish you by up to 60 days in the Broward County Jail as a result of this open plea. Do you understand that?
Yes, Your Honor.
Yeah, I'm not going to do that, but I need to tell you that I can. You understand if you're not a citizen of the United States of America, the entry of this plea is going to result in your deportation?
Yes, Your Honor.
You understand you have an absolute right to legal representation by the attorney you're choosing. If you couldn't afford an attorney, I'd appoint one to represent you free or for greatly, greatly, greatly reduced charge. Do you understand that?
Yes.
You understand you're waiving every right, every defense, everything you ever saw, thought of, heard of, read in a book, saw on TV, everything Judge Judy said, saying, I just want to be done with this. Do you understand that?
Yes, Your Honor.
All right, you understand you're doing that at your own peril.
Yes.
You understand as a result of this plea, the state of Florida is going to assess points to a criminal score sheet. If, in fact, you're convicted of a felony at a later date, this plea will result in additional increased penalties as a result of it. Do you understand that?
Yes.
You understand if you're not a citizen of the United States of America, and I know I already asked you this, but I'm asking you again, you're going to get deported. Do you understand that?
Yes.
You still want to resolve this case?
Yes, Your Honor.
Anybody threaten, force, or making you do this?
No.
How do you plead?
Guilty.
All right, I accept your guilty plea. I withhold adjudication. Court costs. Have a good day. Bye-bye. Ivan Matos. Ivan Matos.
Mr. Mathis, come on up, please.
Mr. Matos, you're charged with a no bond hold. You have a hearing on August 24th. Good luck, young man.
So much, sir.
Nathan Blake. Nathan Burke. I'm sorry, Nathan Burke.
He's approaching, Judge.
All right, Mr. Burke, you apparently violated the terms and conditions of your probation. Your bond set in the amount of $500. Good luck. Jose Garcia.
Garcia, come on up, please. Judge, Mr. Garcia is approaching. And in speaking with Mr. Garcia, he wishes to ask the court if you were considering resolve his case today.
Prior criminal history on Mr. Garcia.
One moment, Your Honor.
Mr. Garcia, hang on 1 minute. I'm going to hit, you're not going to see me because he's looking at your criminal history and I'm going to eat a donut. So hang on.
No, it's still.
Still, 2016, but it's not.
Your Honor. Oh, I'm sorry. No. Theft from earlier this year actually was resolved last week or a couple weeks ago. Or yeah, yes, it was last week. Theft 2016, theft 2016, battery on a law enforcement officer resisting with violence 2015, theft 2012, burglary of a conveyance and theft 2011 with a violation of probation, falsely impersonating a police officer and battery 2011 with the VOP. Then we go back to 2009. So. In 2016 here.
All right, Mr. Garcia, you have an extensive history. It indicates to me that you're probably either homeless or you have some financial issues. I get that. What I don't get is why you're drunk if you're homeless. What I don't get is why you're allegedly told the police when they told you to leave you didn't care about getting arrested. Now, apparently 24 hours later, I assume you're sober, you do care about getting arrested. You apparently resolved a case less than 10 days ago. So this is kind of a systematic pattern here where I understand your life might not be what you hope it is. And I do sincerely hope it gets better, Mr. Garcia. But having said that, the criminal justice system doesn't serve the purpose of following you around and cleaning up after you. If you want to resolve this, I'll let you do it, but you're going to spend 10 days in Broward County Jail. Do you understand that?
They got it wrong.
May I have a moment to talk to him?
Absolutely. If he wants, I'll put him on paper, but I don't think that's going to work out well for him.
Sure. I understand where the court's coming from. he resolved
defense
an
motion for
offense
R1
from what you said about like less than 10 days ago.
Apparently.
My understanding is that offense was also a nonviolent misdemeanor offense. We're here faced with a similar nonviolent misdemeanor offense.
Can I read you the report? Have you read the report?
No, I have not.
All right, let me read it to you. All right, I responded to the above business. This is a police officer in reference to a call for service. Upon arrival, I was told by the business representative that defendant Garcia was drunk, causing a disturbance and disrupting the normal operation of the business. The business representative asked me to trespass defendant Garcia. The defendant was told by the business representative to vacate the business. I trespassed the defendant Garcia from the business and told him to leave immediately. Defendant Garcia refused to leave the business and told me that he did not care about being arrested. The defendant told me to arrest him because he was not going to leave the business, and the defendant was taken into custody. He has something similar. I don't know the facts. We can both agree I don't know the facts about 10 days ago. How do I make him stop doing this by letting him get out of jail?
Like I said, my understanding is that business is a cooperative feeding center that feeds the homeless. Hold on. That's what I believe that business is. I believe everyone that goes there has a certain appointment. When a person is under those, and I don't pretend to know that his situation or pretend to feel the plight that he's feeling or the homeless is feeling, but Judge, the only thing I can see is it's a nonviolent offense. He's homeless. He can't afford possibly the bond of $25. But serving 10 days in Broward County Jail, Judge, I just don't see how that's fair.
I would also point out that the Chief Judge has made an indication to all judges in this circuit that nonviolent cases such as Mr. Garcia's should be considered of paramount importance of not having people warehoused in the jail under these circumstances.
Well, do you really think it's warehousing him when he keeps getting arrested again and again and again? Law enforcement's not looking for him.
I don't think we can carry the weight of the world on our shoulders, Judge, but to have this man occupying a cell in the jail seems to be counterintuitive to what the Chief Judge is trying to accomplish.
Respectfully, with all due respect to you, the Chief Judge is an administrative supervisor who gives guidance on thought processes. We're elected individually by the residents of this county to use our best judgment in how to resolve cases. I think that I am one of the most compassionate and lenient judges there is in this circuit in the vast majority of situations. However, if you're coming in once a week for criminal conduct and you're turning around and walking out with no consequences, I think that we're creating a system that fails Mr. Garcia in doing that. I'm more than willing to give Mr. Garcia a $25 bond. I'm more than willing to come down there and give Mr. Garcia a ride to a homeless shelter and check on him daily. But he's got to stop getting arrested. That's the end of this discussion. So, Mr. Garcia, with all due respect to you, all right, you've got to stay away from law enforcement. The way to stay away from law enforcement is not to look at them and challenge them to arrest you, which is apparently exactly what you did. Now, all of a sudden, after you make law enforcement waste 3 or 4 hours of their somewhat valuable time, you want to get out of jail. I understand that. I respect that. I don't want to be in jail either. But having said that, you seem to have, and I'm not being sarcastic when I say this, a proclivity of getting yourself arrested. When they tell you to leave and you choose not to leave, it's never going to end well. So in light of the fact that you did this less than 2 weeks ago, in light of the fact that the property representative told you to leave, you said no. Law enforcement told you to leave, you said no. You then told law enforcement, arrest me because I'm not leaving. I'm respectfully in my position and broadcasting you, if you resolve this case, you're going to get 10 days in jail. I'm telling you that so you make an intelligent, informed decision. I could tell you you could enter an open plea and not tell you what I'm going to do and then hit you with 10 days in jail. So what would you like to do, Mr. Garcia?
Let the judge know what you want to do.
At this point, I won't take the 10 days, Judge.
You will not? Okay, your bond set at $25. Good luck, young man. Daryl Vollmer.
That's North Broward, Your Honor. Here's another medical reset. I have quite a few of them up here today.
Is it the food?
I could be a med reset too if you like.
I think we both could. Joselito Gonzalez.
He's here, Mr. Cosby's here.
All right. Good morning, sir.
Good morning.
For when he comes back and I review his PC. I'm not right there. I know.
All right, the court does find probable cause. Your bond set in the amount of $25. Does he want to resolve it?
Yes, Judge.
State, any concerns with Mr. Joselito Cosme Gonzalez?
Your Honor, is this a municipal ordinance? Or?
No.
Oh, okay. Let me see.
I think he's going to be under COSME.
Yeah, I have it right here, Judge. Yeah, it's a trespass from a few months ago, but that's it as far as Broward goes, Judge.
Joselito, you want to resolve this case today?
Yes.
You understand if you're not a citizen, you're going to get deported.
Yes, I do.
You understand you have the right to legal representation by the attorney of your choosing. If you couldn't afford an attorney, I'd appoint one to represent you.
Yes, I do.
All right. Anybody threatening or forcing you, making you do this today?
None whatsoever.
All right. You sure you want to do this?
Yeah.
All right. How do you plead?
No contest.
All right. Withhold court costs. Do you really have a tattoo that says Crazy Coconut?
Yes, I do, sir.
That's outstanding. Sir, I'm going to give you a withholding court cost. Have a good day. Stop being a crazy coconut, all
I
right?
hear what you gave me.
You're getting out of jail. Have a good day. All right, bye-bye. Omar DeCarish. Omar.
Mr. Omar DeCarish, it's your present, Judge Amain.
Good morning, young man. Your bond's set at $1,500 from an active capias. It's a battery. I can't touch that. Good luck to you.
The only thing he wishes to ask, Judge, is I know he actually went ahead and surrendered himself with his bondsman.
Okay.
And his bondsman said he was going to go ahead and post his bond, and he's here. So I wanted to know.
Do we know if we've started the bond process on this defendant? All right. Give Brian something to do over his long lunch today. Oh, we got nothing here. Sorry. Sir, if your bondsman is going to do that, I'm sure it'll be coming at some point. Richard McEwing. Richard McEwing.
Mr. McEwing is your present, Judge, of the municipal ordinance case.
All right, sir, your bond on this case is set at $25. Good luck.
Hey, can I try this now? I know, I'm pleading no contest.
Oh, you do? Well, you got to tell me that. You want to resolve your...
I didn't understand. I didn't talk to this gentleman to my right at all.
Okay, that's because the city's charging you. You want to resolve this case today?
Yes, sir.
How do you plead?
No contest.
Withholding court cost on both counts. Good luck. Paul Dewis. Paul Dewis.
Mr. Dewis is your present, Judge. Come on.
All right, Mr. Dewis, you have a capias in the amount of $2,000 for one count of theft. Good luck.
Judge, respectfully and speaking, Mr. Dewis, what caught my attention is normally, like I know, with capias, BOPs, sometimes our hands are tied. But from what I noticed, this is a 2005 case.
Is it really? Oh, yeah, it is.
No.
All right.
Speaking to Mr. Dewis.
Paul, raise your right hand. You swear affirm, tell the truth, the whole truth, nothing but the truth?
Yes, I do, Your Honor.
Have you been in trouble since 2005? Don't lie to me.
No, sir. What happened was...
App. Stop helping. Stop. Shh. Be quiet. Stay.
Out of Broward
Yes,
County.
I have. Yes.
Out of Broward County, 2009 grand theft, 2010 theft. Out of Palm Beach County, 2011, he was picked up on a failure to appear and a theft. Your Honor, I would also just note, yes, it is a 2005 case. The capias was not issued in 2005. He failed to appear in 2005. He was given a new court date, and as you can see, this capias was issued in 2012. So he was gone for 7 years, and now he's been gone for another 5 years.
Your Honor?
Sir?
I had no idea that this warrant was there. I went through drug court in 2009 for 18 months, and since then I've been clean and sober, and I've turned my life around. I had no idea that
Counsel, what do you want to do with this? I'm willing to take care of it.
Let me ask him.
Yeah, find out. Mr. Dewis, you're doing so at your own peril. Do you understand that?
Yes, sir.
All right, you have a statutory, a legal, a constitutional, and a moral right to have a neutral arbiter review the facts and circumstances in your case. In other words, what you're charged with, to read the probable cause affidavit, to read the reports, to decide whether or not the state's met its burden. I don't have any of that today. Are you willing to waive that right for me to make a decision on your case?
Yes, sir.
Do you understand that this potentially is going to open you up to greatly increased scoring? In other words, it's going to tie your entire criminal history together if you commit another offense at some point in the future, and you could get a state prison sentence as a result of this.
I will not be committing another offense.
But do you understand that if you do, it's dangerous? All right? Anybody threatening or forcing you, making you do this?
No.
You understand you have an absolute right to legal representation by the attorney of your choosing. If you couldn't afford an attorney, I'd appoint somebody to represent you in this very, very old case.
Yes.
You also understand there's a reasonable likelihood that potentially you would be found not guilty by default, or quite honestly, the fact you outlasted everybody.
Yes, Your Honor.
You still want to resolve this case?
Yes, Your Honor.
All right, sir, raise your right hand. You swear firm to tell the truth, the whole truth, nothing but the truth?
I do, Your Honor.
Put your hand down. Tell me your full legal name.
Paul Dewis.
Paul, you under the influence of alcoholic beverage, controlled substance, anything of that nature?
No, sir.
Are you currently under the care of a psychologist, psychiatrist, anything of that nature?
No, Your Honor.
Should you be?
No, Your Honor.
All right, now, Mr. Dewis, you've listened to me talking to you. I've talked to you a lot more than everybody else. Do you know why I've talked to you a lot more than everybody else? It's not because I like you, although you do seem like a nice enough fellow. It's because you are in peril here. You are rolling the dice that things are going to work out for you. And 2 years from now, when you get another criminal offense, some smart attorney's going to say, he pled this out at magistrates. Maybe I can get him out of it. Do you understand what I'm saying?
Yes, Your Honor.
You sure you want to do this?
It's up to you. You don't have
Listen, I'm not going to commit any more offenses. Yes, Your Honor.
You sure you want to do this?
one more second.
All right. Let's not get me eating the bagel on the TV, okay? Promise? That's the last thing I need to explain.
I understand, and yes, I do, Your Honor.
All right, sir, how do you plead to this misdemeanor count of theft?
No contest, Your Honor.
I do find you guilty. I withhold adjudication. Good luck, young man. Tanner Hargrove, state over your possible concerns. He's been in court. He's been in jail. He's been everywhere.
And for the record, I have no objection. I just wanted the court to be clear
Thank
on.
you. Mr. Hargrove, you're charged with 1 count of misdemeanor battery. Your bond set in the amount of $1,000. You have no contact with the alleged victim. Do you understand that?
Yes, Your Honor.
Good luck, young man. I hope it works out for you.
Judge, he's asking if you would consider pretrial release. He lives in Lauderhill.
Does he qualify?
Your Honor, he refused pretrial. He signed the papers.
He refused pretrial.
Yep.
Judge, in speaking to him right now, I've had a better opportunity to explain what pretrial is. He lives with his mother. If they could verify his address, that's where he would like to go. He's working 2 jobs to try and support himself He works for a telemarketing job, and he works for
As a matter of fact, it's noted here, he says he wants a ROR. And that's when he refused, he signed the paper.
As far as criminal history out of Broward, Your Honor, 2014, possession of cannabis. 2008, burglary of a dwelling with battery, felony criminal mischief, battery, criminal mischief, and assault. He violated probation, was sentenced to 364 days county jail. 07, resisting without violence, leaving the scene of an accident. 07, trespass. 07, loitering.
So apparently when he met with pretrial, he knew enough to tell him that he wanted an ROR. He wasn't interested in supervision.
Correct.
Bond set at $1,000. Good luck, young man.
Yes, sir.
Kevin Bernard.
Mr. Bernard, come on up, please.
Good morning, Your Honor.
Good morning, young man. How are you today?
I'm good. How are you?
Yeah, I'm all right. Brian, I'm going to go sidebar. Hey, Brian.
Yeah, I'm ready.
Hang on, the button's temperamental. All right, so this guy's girlfriend is pregnant with his kid. Right? Seven or eight times. Do I have the statutory authority to order no contact on a criminal record?
See, why not? I mean, I think that there's a causal relationship between him and the victim. It was her property. She was standing next to it. She couldn't leave because she would have had to leave the car behind if she did. So,
I think there's enough.
I wouldn't object to it if that's what you wanted to do.
And I think in addition, even if she wasn't the illicit victim, based on the report, it appears she's a witness, and certainly the court can order no contact with any witnesses to the offense. I got my moments.
Also, the report says that she was in front of the gas pump.
That I noticed.
I have confused with the belly button.
Agree with that, and he did admit to it. All right, Kevin, the court does find probable cause of the criminal mischief. I'm going to order no contact with Nicole Rogers of any kind. You're to have no contact with Miss Nicole Rogers. Your bond's going to be set in the amount of $100. Good luck, young man. Stay away from her. Sir, bring him back for 1 second.
Sir. Judge wants back.
I'm not saying you're going to do this. All right, don't be offended. The fact that she is allegedly pregnant and that you know she's allegedly pregnant, if you touch her in any way, you understand that's a felony punishable by prison. All right, I'm not saying that to say you're going to do it. I'm just cautioning you. Have a good day, young man. Tevis Robinson.
Conti, Judge.
Good morning, sir. How are you today?
I'm good, Judge.
All right, you have a capias for a felony charge in the amount of $100. That's pretty interesting.
Well, it's a misdemeanor charge that was added to a pending felony, Your Honor.
All right, your bond's going to be set in the amount of so he already has another felony?
He's got a $1,000 bond on possession of cannabis with intent, but he also has a no bond out-of-state hold on a VOP.
I'm going to release the defendant on his own recognizance on this charge. Good luck, young man. Sounds like you have bigger issues to deal with. Andrew Flowers.
Judge, excuse me,
Mr. Flowers is here present, Judge?
What'd you say, BSO?
because of the extradition charge, if you RR him, that's not gonna help him go to the other state. So.
He won't get game time also.
Okay, bring back that guy up at Conte. What was his name?
Tevis Robinson.
Mr. Robinson, come on back. Conte. I want that job. All right, we're going to reset Mr. Robinson, assuming we can't find anybody at Conte.
Their line's busy.
Okay, but you all have to transfer. Thank you.
Are they bringing him back?
There he is.
Your Honor, I gotta get him. Give me a few minutes.
Okay. It was like 10 seconds ago. Where'd you put him?
Fast.
No, there's a stairwell. They go.
What do you got, like an express elevator over there I don't know about from all the times I was in?
This is Conti, man. This is first class over here.
All right, then. Andrew Flowers. Andrew Flowers.
Mr. Flowers is here, President Judge in Maine.
Mr. Flowers, good morning. You have a no bond 3. You have 2 no bond warrants and a $250 warrant on your misdemeanor case. You're going to be in court in the 29th, which I think is Thursday. Good luck, young man. Maybe tomorrow. What's today? Oh, no, it's going to be in 6 days. I'm sorry I misled you. All right, Gladstone Fuller. Gladstone Fuller.
That's North Broward, a medical reset.
The food, got it. All right, Casey Mulhall. Casey Mulhall.
I believe it's a medical loan, Judge.
Medical loan, thank you. Sean Frank. Sean Frank.
Frank, come on up. Judge, he's here, President of Maine.
All right, Mr. Frank, good morning. Give me a minute to read this, please. Give me one moment.
No, Your Honor, that involved different family members. Actually.
Hear me, Mr. Frank?
Yes, sir. Yes.
All right, so you're charged with 5 counts. The first count is burglary, dwelling, structure, or conveyance armed. Second is burglary with an assault or battery. The third is aggravated battery on a person 65 years of age or older. Fourth is aggravated battery, and the fifth is tampering in a second-degree felony proceeding. State, I don't see probable cause for the 5th count. Can you tell me where it is?
One moment, Your Honor. Oh, Your Honor, that is the allegation is starting the second last paragraph regarding the calls that were made.
The court still doesn't see probable cause. It says the subjects. There's 3 subjects. It does not specifically insinuate or state that Sean made those phone calls. And in addition to that, it's nothing more than a leap, in my opinion. Am I wrong?
Well, Your Honor, the only thing I would say is, and I understand the court's viewpoint, one moment, Judge Usan, when reviewing the warrant, and I can't say what his reasoning was, found that there was in the language probable cause based on the language.
I understand that. And Judge Usan is arguably one of the smartest people I know. Having said that, I don't find it. So as to the 5th count, I'm going to release the defendant on his own recognizance. As to count 1, the court does find pursuant to Yazara versus State, proof is evident, presumption is great. As to the armed burglary, any response from the defense at this time?
Yes, Your Honor. In order for the court to find proof, evident, presumption great, the state must establish that burden of proof. It's the highest burden we have in the criminal justice system. They have failed to meet that burden at this point in time. They have introduced no evidence. They've called no witnesses. And while the Yazara case does state that the court can find probable cause, proof, evident, presumption great from a probable cause affidavit, it doesn't say that you have to, and it doesn't say that that's applicable in all cases. In this particular case, the defense's position would be that this probable cause affidavit and this warrant to arrest do not meet that standard, and we would ask that the court set bond for Mr. Frank.
Excellent argument, counsel. Defendant is remanded custody of Sheriff Broward County on count 1, no bond. Count 2, burglary with an assault or battery, I do find probable cause. The question on that is that a no bond felony? I don't think it is.
No, burglary with assault or battery is a punishable by life offense, Judge.
Oh, it is?
Yes.
Oh, all right. Well, he's remanded no bond on that one, too. Count 3, I'm going to leave at $25,000. Count 4, I'm going to leave at $25,000. Count 5, as I mentioned, I'm going to release him on the own recognizance. No disrespect to the judge. If, in fact, he was to be released somehow at this time, I'm ordering no contact with any of the alleged 3 victims in this matter.
Your Honor, the only reason I would ask that the no contact order be applicable whether he's released from custody or not. The only reason is my concern is while it doesn't note it
You're not to have any contact in jail in any way, shape, or form with them. Do you understand BSO listens to your phone calls? All right, good luck, young man.
Judge, in reference to counts 3 and 4, those are set currently at $50,000. And speaking of Mr. Frank, his whole source of income is he's self-employed. He recycles precious metals like aluminum cans, things of that nature where you sell for the value once he goes ahead and scrap metal. The amount of income he gets from that is minimal, about $300 he made last month. There's no, the only other person that can help post his bond is his father, who works in the similar field. Judge, there's no way he can come close to the $50,000. I'd ask you at this time to consider lowering the bond on count 3 and 4 to something more reasonable pursuant to Mr. Frank's financial resources.
Here's my logic on that. He's got 2 no bond warrants. They're all going to the exact same judge because they all occurred in the exact course and conduct of events, assuming they're true, and I'm not saying they are. Sir, I'm leaving your bond at what it is because this is literally an exercise in semantics. In my opinion, the public defender is doing exactly what they're supposed to do. I could order you released on a Vespa. It doesn't change the fact that you have 2 no bond warrants. So anything that we're doing right now is immaterial. Your bond will remain what it is. Thank you.
Judge, whenever you want, I got the information from Ms. Resic's case you reset on the prostitution.
Okay, thank you. We'll get to her when we're done with everybody else.
Okay.
Anthony Agro.
Judge Fry?
Yes?
Agro, come on up, please.
Conti has Mr. Robinson back when you're ready.
Okay, let's do Mr. Robinson real quick, or whatever his name was. What's his name?
Tevin Robinson.
Tevis Robinson.
Tevis, I'm sorry.
What was I telling him again?
You're going to put the, I believe you're going to put the $100 bond.
Oh, listen,
so
I was
get
going to
game
release
time.
you on your own recognizance because in reality, you're going wherever you're going for whatever you're alleged to have done. But I'm going to change that to $10. The reason I'm changing that to $10 is so you get game time on your cases.
Can I ask you a question, sir?
I highly suggest you don't, but sure.
I just asked one. That the felony that I guess the state was saying I was in for the possession with intent to sell. I just wanted to ask, was it filed? That's all.
State?
Yeah, I imagine because we filed this ad charge with, it's an ad charge to that.
I would assume, and you know what they say about assumptions, I would assume it was because this latest charge is an ad charge. In order for it to be an ad charge, there had to be additional charges. So the educated guess is yes.
I'll just confirm.
He's going to look right now, okay?
Yes, yeah, because it doesn't
Just
show.
hang on. We're looking right now. Hang on.
And it probably isn't, and that's why we're hearing the ad charge. It was filed as charged. It's probably not showing it because it just hasn't been.
It was filed as charged, to answer your question.
All right.
Good luck, young man.
All right, thank you.
Thank you, Your Honor.
All right, Conte, you got anything else up there?
Not this morning.
All
In
right.
the afternoon, you get to see me.
All right. Let's go to North Broward. North Broward.
Okay.
What else you got?
I got plenty for you. Come on in, Mr. Myron. Myron Coleman.
Myron Calaman. Myron Calaman. Good morning, Myron. You're charged with carrying an electronic device or weapon and petty theft, third or subsequent offense.
Excuse me, sir, mess.
I suggest you don't.
Yes, sir.
Let's see. I wasn't here. Oh, he was. Oh no, he was here last. He was here last week.
All right, State, is there anything I need to know on this
I
one?
believe
Your Honor,
pretrial has.
the defendant was placed on pretrial supervision on the 17th of August. He reported to the pretrial office and was instructed, based on this court's finding of probable cause on the new arrest, we're going to ask that he be revoked in case 17-9664 CF10A, one count of grand theft in the third degree.
All right, sir, you additionally appear to have case number 179664 CF10A that's open and pending. You were placed on pretrial release for that. I reviewed the probable cause in this affidavit having to do with you allegedly going into Dick's Sporting Goods, taking an airsoft gun out of its package and walking out the front with it. I do find probable cause that you committed the offense. As such, sir, in case number 179664 CF10A, the court revokes your pretrial status. In that case, you remain in the custody of Sheriff of Broward County, no bond.
Judge, you don't have to hold him no bond. And speaking to Mr. Calaman, he's been living here in Florida since 2011. He has his grandmother, his mother, and his sister live in this community. He's currently a senior at Whispering Pines High School. He was on the basketball team last year. He's trying to get the rest of the credits that he needs to graduate from high school. He's interested in pursuing a career in music or auto mechanics. He's also given me the number of his sister, who I'm going to call to see if she can stay with him. So even if the court does revoke his pretrial release, I'd ask the court still to set a monetary bond on case 17-9664.
Priors?
One moment, Your Honor.
Apparently, if he's still in high school, he's probably just turned 18.
Yes, sir.
I mean, but it does. Yeah, I was going to say because
I'm going to check out what his juveniles are.
Is he?
I'm proud of you. I'm really proud of you.
Is he on probation?
Defendants remain in the custody of Sheriff of Broward County, no bond. Counsel, if you'd like to look at his prior criminal history, you can feel free to do so if you'd like to give an argument as to why. in light of that history, Brian, which
We've discussed it, Judge.
Okay. So is there anything else you'd like to add at this point?
No, I'm going to call your sister, Myron, and we'll get somebody to set a bond hearing for you, okay?
So, sir.
Sir, I suggest you don't speak. I've just ordered you placed in custody, no bond. It doesn't get any worse than that. So you're in a very perilous situation. I suggest you do not speak to me.
Yes, sir.
Good luck, young man. Anthony Agro. Brian, I'm sorry, just. Anthony Agro. Oh, wait a minute. We're at North Broward.
You want the rest of mine at North Broward? Mr. Tavares Goodwin would be next.
Actually, hang on. I'm going to go to Paul Ryan first.
Okay.
Paul Ryan, never mind, the lights are off.
Tell free.
All right, North Broward, you're back. Who do you have next?
Mr. Goodwin, Tavares.
Tavares Goodwin, come on up.
One side yourself.
Good morning, young man.
Good morning.
Okay. What's the writ of arrest for? Is that child support? All right, the writ of arrest for $358. I do find probable cause as a criminal mischief.
Judge, I don't see an amount that makes it over $1,000 on this probable cause affidavit.
I agree with you on that. I'm going to set his bond. I'm going to reduce his bond to $100. However, I'm going to order him not to have any contact with his mother. Do you understand that?
Yes, sir.
I mean, no contact at all. If you have any contact with her, you're going to get arrested. Do you understand that?
Yes, sir.
State, do you think that satisfies the concerns?
I'm satisfied, Your
All
Honor.
right, thank you, Counselor.
I'm going to call your brother, Tavares.
All right, who you got next?
So,
Paul Douglas. Paul Douglas.
Mr. Douglas.
yes, sir.
Good morning, Paul.
Good morning.
Hey, Eric. So, Paul, there's a whole bunch of sick people up there. Do you think it's the food?
Yeah, I don't know what it is, sir.
All right, you have a no bond warrant. I can't help you with that. You do have caught on the 24th at 8:30 from a 2016 felony. Good luck, young man.
Thank you.
Last one up North Broward is Eugene Tucker.
Mr. Tucker.
Hey, how you doing?
Good morning, sir. Mr. Tucker, you are charged with a no bond felony and a $100 bond misdemeanor. Good luck, young man.
Hold on. What's the charges?
Well, the felony capias is for grand theft of an automobile.
No, they dropped the charges to grand theft.
State, is that true?
Because that's what I missed court for.
Even
I was
if-
in a hospital.
I'll check, but even if they drop the charge of grand theft, like, same situation.
So you have a no bond warrant. Do we know when his next court date is?
I was wondering if I can get a bond because I was in the hospital when I had to go to court.
How come you ended up in the hospital, Eugene?
Are we really doing this on the record?
Yeah, I got to ask him.
Okay, how'd you end up in the hospital?
I got bit by a spider, and it's still kind of bad.
Oh, nothing to do with your arrest, though.
No, my arrest was my bondsman.
Okay.
He came and got it.
Okay.
I didn't catch a new charge. That's why I said I understand how I got a misdemeanor.
Don't look at me. You got to
No, I'm looking at judge. I don't understand. I don't understand how I got a misdemeanor.
You have a misdemeanor from 175351 MO10A. So generally that means either Fort Lauderdale or Hollywood picked you up.
The police didn't pick me up.
Hang on.
Don't say anything else about the facts, Mr. Tucker.
Stop helping. All right. Apparently, Eugene, I've never seen this one before. You disturbed a trash can. Hang on. Let me think about this for 1 minute. I just got stop helping. I got to figure out where this allegedly happened.
AV.
Oh, see, I told you to
Stop
be quiet.
helping. You just put yourself at the scene of the trash can.
what he's saying.
Yeah, I know.
We're not making fun of Davy's ordinance. Don't misunderstand me. I've just never seen it disturbing the trash can. All right, hang on. We're going to be sidebar for 1 minute. Actually, no, we're going to be off the record for 1 minute. Just stay there. some very competent discussion with the Office of the Public Defender. They're very good at what they're going to do. I'm going to release you on your own recognizance on the trash can violation. However, you are being held no bond on the substantive felony case. So good luck with that, okay?
Hold on. The felony case.
All right, holding up. Go ahead. What do you want to tell me?
Okay, the felony case, I think it was a Grand Theft Auto, and then they charged.
You know how you admitted that you were in Davie for the trash can event?
Yeah, because I'm not going to lie to the honor, and I'm not going to lie to the court.
And I appreciate that. But by the same token, there's sometimes you should be quiet. And let me put it to you this way. Every once in a while, my wife says something that I know is not true, but I'm smart enough to just be quiet because the consequences are more than if I pointed out that she was wrong. This is one of those events for you.
This is all I'm saying, Your Honor.
No, don't say anything.
I missed court because I was.
Don't say you missed court.
That's your attorney.
Lying and being quiet are not the same thing.
Well, if I could tell the honor face to face, then I'd rather tell him.
You're going to be held no bond no matter what. There's nothing that the judge can do about it anyway. So you're going to have to wait until you go in front of your judge.
Eugene, listen to me. Listen to me for 1 minute, okay? Can you look at me? Can you see my face?
Of course. Look up, son.
I'm not. Yeah. Okay. That better. I'm not trying to give you a hard time.
Yes, sir.
But I do not have the authority, no matter what you tell me right now, to set aside that no bond warrant.
Okay.
So there's absolutely no chance, no matter what you tell me, of me being able to fix that right now. And at a minimum, the spider bite issue in and of itself is not going to get you out of this dilemma. Having said that, the Office of the Public Defender, that's the young man who was speaking to you, telling you to be quiet. All right. Do you have an attorney now?
No, on this case, I think it might be, what it's called when...
Public defender?
Yeah, on this, I don't know even know what I missed. I think I missed court for the Grand Theft. I don't think I have a...
You're really, really not helping.
All right. So having said that, you're going to... Do we have a court date for Eugene? Because Eugene, he seems pretty sincere about his spider issue.
They usually don't when it's on a capias, Your Honor, and...
There's a status conference set in front of Judge Cholera for August 25th at 10 a.m.
All right, so you're going to be in court on the 25th, which I think is Friday. All right, you explain that to Judge Cholera, and we'll see what he does. Eugene, I'm not blowing you off, I promise, but I just can't fix this for you right now, assuming it was appropriate to do so. So you'll be in court on Friday.
Kind of about the trash can thing.
Yeah, good luck with that. Don't tip trash cans in Davie. You know, if this was a different environment, I'd really like to hear this story. But don't tell it to me. Have a good day.
Judge Fry, only other one that you have paperwork on up here is Corey Brown, but he's a med reset.
Med reset on Corey Brown.
Yeah.
All right, so we're done for this morning at North Broward?
Yes, North Broward is done. Thank you very much.
Hoorah.
First appearance at 11.
Hoorah.
All right, Anthony Agro.
Mr. Agro is coming up again.
All right, good morning, sir.
Good morning.
Hang on for 1 second. Eric, come here.
I know, that's what I was wondering. No, it's,
That was just in her office from Judy.
oh, they don't give it to us, so. I recognize the name. The community, because after this one we're pretty much done school.
Say hi to your mom for me. I will. I always say that. It sounds so inappropriate.
She always asks that.
Yes. Say hi to your mom for me, Eric. All right, then. Mr. Agro, I'm sorry. My old public defender was here to visit me. And as much as I like him, I like his mother more. She is a cantor at a local synagogue. So, Mr. Agro, you're charged with 6 counts. 1 count's grand theft, 2 counts of falsely making credit cards, 1 count of fraud, utter or false bank bill, and 2 counts of possession of a fictitious driver's license. Give me 1 second to read this, sir. What are the prior criminals on this individual?
Your Honor, I'd have to check in this. I wasn't getting any hits in the system. I'm showing he has no ties to the community. I'm showing a residence in Staten Island. Did pretrial have any notes on him? Okay, thank you.
Court does find probable cause. Are there any ties to the community that we're aware of?
Judge, respectfully, Mr. Agro was visiting from New York. He lives in Staten Island. He lives with his partner. They've been residing in the same location since 2008. Mr. Agro's source of income is he's collecting disability. The only person that he can potentially contact is his partner. However, he's unemployed at this time. He's 52 years old. He's a registered voter in New York. This is his first charge ever in his life in New York or here or anywhere. Judge, he believes that we're going to be requesting a phone order, but he's not too sure if his phone is charged or not. He's in a very difficult situation because right now his family, his friends do not know that he's currently incarcerated here in Broward County. Right now he has no sort of financial resources on him or anyone to contact to post his bond. I do understand, Judge, the state's concern. He has no ties to the community, and that's one of the things you have to consider. But I'd ask you to, at this time, potentially focus more on the fact that he's 52 years old, never been in trouble with the criminal justice system, and consider an ROR at this time.
Well, that's not really my only concern. My additional concern is he's got 2 driver's licenses with different people's names on them, one of which has his picture on it.
Did somebody manage to hack into the Citibank's computer system and change the phone number for the contact? That they called somebody as the contact on the hacked 4 minutes before he walked in the bank check, and they said it was a legitimate check, yet it was sequentially numbered and different from the check before it, and that when they managed to retroactively look at the records, established that in fact the person they spoke to wasn't the owner, at which point they called the owner of the business who advised that there was fraud. The defendant apparently came to the state of Florida, and in his brief stay where he apparently doesn't have any money, managed to come with multiple IDs from multiple parties to our state to participate in a very organized criminal conduct. Sir, I'm not saying you're guilty of this, but this was masterfully done. All right, it was very orchestrated, very planned, very intelligently done. It was almost like a military operation. So, sir, with all due respect to your financial hardship and situations, on count 1, your bond set at $1,000. Count 2, $1,000. Count 3, $1,000. Count 4, $1,000. Count 5, I'm raising that to $1,000. And count 6, I'm raising that to $1,000. Sir, you may return to New York. However, I'm cautioning you that you're going to have to appear at all your court dates, and that your bondsman is going to have to ultimately decide whether or not you can go back to New York. Good luck, young man. Michael Wilford. Michael Wilford.
Mr. Wilford is here present, Judge Amain. Good morning, Your Honor.
Good morning, young man. You have a no-bond warrant in case number 178411 CF10A. You also have a habitual suspended license charge. In that case, I'm going to release you on your own recognizance because, quite frankly, you're already being held on the other case. Or is this another one of those money issues?
Judge, respectfully, I would ask you at this time not to release some ROR.
All right,
I would ask you to consider
$50.
Thank you, Judge.
All right, hang on. BSO's mad at me. Hang on. Don't let him leave. Don't let him leave. Don't let him leave.
I'm not mad. Just
BSO.
confirm you're releasing him on that violation?
No, I'm $50 on the suspended license.
Oh, okay.
He's no bond on the violation.
Oh, okay.
All right. Thank you, sir. You're free to go. Alex, you're free to go out of there. All right. Alex Castro. Alex Castro.
Mr. Castro, come on up, please.
All right, Mr. Castro, you apparently have a no bond hold on a misdemeanor case. That's interesting.
Yeah, wait, what? It says felony, but it's clearly not. It's from Judge Pohl.
Judge Pohl issued a no bond misdemeanor warrant.
The reason he did that was as it looks pursuant to his he was supposed to surrender to Broward County Jail. He did not.
Okay. All right, you're remanded no bond on count 1. Count 2, I'll release you on your own recognizance. Good luck. Salazar Luis. Salazar Luis.
Mr. Salazar Luis is here present, Judge Amain. He declined to serve service as a public defender. Good morning, Your Honor.
Good morning, young man. Prior criminal history?
One moment, Your Honor.
So you're charged with possession with intent to sell, manufacture, deliver cannabis. You apparently had in excess of 20 grams of marijuana, multiple little baggies and things of that nature in your vehicle. I'm not asking you to say anything. I'm just letting you know what you're charged with. You're also charged with felony possession over 20 grams. State?
Does pretrial have any notes? He's not on our list, Judge.
All right, sir, on count 1, your bond's going to be set in the amount of $1,000. Count 2, your bond's going to be set in the amount of $1,000. Good luck. Elliot Taylor. Elliot Taylor.
Mr. Taylor, come on up, please.
Mr. Taylor, good morning. You have a no bond warrant. You have court on August 24th at 8:30 in the morning. Good luck, young man.
Excuse me, Your Honor. There's no way I can get in court sooner.
No. Sorry. That's in like 2 days. Isn't it? What's today? 22nd?
Yep.
Oh, 2 days is pretty good.
Nope.
All right. State.
Yes, Judge. Well, Your Honor, we had one other Corey Brown. Was that called?
Yeah, it's medical research.
Oh, okay. Sorry about that.
All right. Okay, here I have the Bynum case.
Yes.
All right, Robert White. Robert White.
Mr. White, come on up, please.
Mr. White, you have a violation of probation with a no bond warrant. Good luck to you. Let's call the young lady back up with the prostitution charge. Ann Resek. Ann Resek.
Yes, Judge.
She's approaching, Judge.
State, is there anything special I need to know about this prostitution charge?
Not that I am aware of, Your Honor, and I can also advise the court. Ms. Risich has been charged under subsection E. Subsection F is the one that has the huge fine.
Okay. So, Ms. Risich, you still want to resolve this case?
Yes, Your Honor.
All right. You understand you're charged with 1 count of misdemeanor prostitution. Is that a yes nod?
Yes, yes.
All right, you understand I don't have the paperwork in front of me. I can't read what you allegedly did or what caused the state of Florida to charge you with this offense. Do you understand that?
Yes.
You understand you have a right for me to review it, and I review it with a critical eye. What I mean is I look for errors in what you are charged with because at that, I keep changing hats. Do you understand what I'm saying, Ann? One point I'm an advocate for you. One point I'm an advocate for the state. Well, not an advocate, but a protector of the state. And ultimately, I'm this neutral person. But in a portion of this, I am looking to find that the state failed to do what they needed to do. And in that portion, it's where I review the reports to see if they had a legal basis to arrest you, let alone charge you. I'm not doing any of that. I'll just be resolving the case. Are you okay with that?
I'm fine with that, Your Honor.
Anybody threatening or forcing you, making you do this today?
No, sir.
All right, where were you when this happened?
I was on where I live, like right outside where I live.
Okay, you want to resolve this case?
Yes, I do.
How do you plead?
No contest.
Withholding court costs. Good luck, young lady. Scott Lomagistro. Scott Lomagistro.
Let's see, I think that was medical loan, Judge.
All right. And so I guess that just leaves us with Mr. Bynum, correct?
Yes, Judge.
Correct, Judge.
Give me 1 second, please. All right, Mr. Bynum, I want to caution you to be quiet. You can talk to me if you want to, but this is the most serious charge we have by law. I highly suggest that you don't say a word. Okay? All right, so state. Let's see, I have an arrest warrant. Does the warrant to arrest defense, have you seen this?
I have reviewed it, yes.
And I have a probable cause affidavit for murder. Have you reviewed that?
I have, Your Honor.
All right, we're going to be on the record in the state of Florida versus Billy Bynum. Mr. Bynum, good morning to you, young man. Mr. Bynum, you're charged with, I guess, 1 count of burglary, unoccupied dwelling unarmed, 1 count of grand theft, 1 count of premeditated murder, 1 count of aggravated assault with a deadly weapon with an out intent to kill, and 1 count of robbery firearm. All right, let's start with the burglary unoccupied dwelling. State.
Yes, Your Honor.
What dwelling did he allegedly enter?
There should be a PC, Your Honor, from August 19th. That should be attached to the, it's not with the paperwork I gave you. It should be attached to the paperwork you were given by the clerk.
Thank you. All right, the court does find probable cause as to the burglary on unoccupied dwelling. The bond will be set in the amount of $5,000. Count 2, grand theft, bond will be set in the amount of $1,000. All right, Mr. Bynum, I want you to just listen to me, okay, sir? You're charged with 1 count of premeditated murder, and that specifically on or around August 18, 2017, you had an altercation with an individual. The probable cause affidavit indicates to me that you and the defendant on multiple occasions allegedly were in contact with each other. You exited a vehicle and you approached the subject. You fired a warning shot, at which point when the subject appears to have turned around and fled, you shot him in the back. When he then hit the ground, you repeatedly shot him while in a prone position on the ground. You did so in front of his pregnant fiance. You did so apparently in front of the mother of your children as well. Subsequent to the investigation, law enforcement met with what I believe to be the mother of your children, and she confirmed the account. I do find probable cause. I do also find, pursuant to Yasaza versus State, proof is evident, presumption is great that you committed the act of first-degree premeditated murder. As such, you're a man in custody of the Sheriff of Broward County, no bond on this matter. In addition to that, I do find that you did commit the offense of aggravated assault with a deadly weapon. That being the warning shot, for lack of a better term, fired immediately prior to killing the alleged victim.
And I apologize, Your Honor. Actually, I believe that charge goes towards the when he allegedly pointed the firearm at the victim's girlfriend, Your Honor.
That could be.
And the only reason I bring that up is because she's considered the victim in that case, and I'm obviously going to be asking for no contact order.
Understand. I'm going to set bond in that amount at the amount of $100,000. In addition to that, State, explain to me the robbery firearm charge.
Your Honor, I gave you a second warrant with the robbery firearm. From Detective John Kidd of Hollywood Police Department.
All right, let's start this again. All right, Mr. Bynum, the court does find probable cause. The court does find proof is evident. Presumption is great that you shot an individual, and then when the individual was on the ground, you repeatedly shot him and killed him. In addition to that, the court finds that you committed a robbery firearm in a separate, unrelated event. The court does find proof is evident. Presumption is great that you committed that offense with an unrelated second party.
I would like to be heard on that matter, Judge.
All right. The court does also find probable cause to believe that you committed a third separate, unrelated burglary charge. Let's talk about the robbery, counsel.
Judge, this is an incident that occurred on October 23rd of 2013. The only information I think against Mr. Bynum is some DNA that was found in a hat that is not directly connected to him or the robbery, and an identification that's done years and years after the alleged offense took place. That is not proof evident presumption great. I agree it could be a finding of probable cause, but it does not meet the highest standard we have in the criminal justice system.
Response, State.
Your Honor, the DNA is linked to it. The detective notes it is found in the vicinity of where Mr. Bynum ran to his vehicle after committing the robbery, and both witnesses, not just one, witness and victim, both identified him with a double blind, noting in the detective notes, a double blind photo array.
Yes, 4 years later.
2.
2013, 2014, 2000. All right, even 2. It's not proof beyond, it's not presumption great. It's probable cause, probably. But it is not proof evident presumption great. Not with that little amount of evidence. And I would point out the court, the state hasn't brought in any witnesses to testify in front of this court. They haven't produced this lineup. They haven't brought any detectives in. Yet they still want you to hold Mr. Bynum with the highest possible pretrial form of detention that there is, which is a no bond hold. In this case, on count 5, the robbery firearm, it's not appropriate.
Your Honor, 2 witnesses in different lineups given by a detective that had nothing to do with the case, where he was put in different different positions, and they only got his identity from the DNA from a hat that was in the area where he was fleeing, seen leaving from the scene to his car to get away from the scene. And in and of itself, 2 years, these people remember the person that robbed them at point blank range.
Thank you, counsel.
Also, Judge, the affidavit doesn't indicate who they identified. It says both victim and witness identified the same suspect as the person who committed the armed robbery upon them on October 23rd of 2013. It doesn't say who they picked out of the photo lineup. It doesn't say they picked Mr. Bynum out of the photo lineup.
Response?
If that is the only issue preventing the court from finding proof evident or presumption great, I have no problem bringing Detective Kidd in to take care of that issue.
All right, the court does not find, based upon the strong arguments of the Office of the Public Defender, that proof is evident, presumption is great at this time. Is the state asking for a reset on this?
Well, is it for all the reasons stated, Your Honor, or is it just for the reason as far as...
The last reason.
Oh, then I would ask for time to confirm that.
That'll be granted. All right, the court is going to amend its decision as to the burglary, unoccupied dwelling, or structure. The court, taking into consideration the other criminal conduct, is no longer applying a $5,000 bond. The bond in that case will be $100,000. Grand theft bond will be in the amount of $1,000. No bond on the first degree or the premeditated murder. $100,000 on the aggravated assault with a deadly weapon. And I guess, would I establish a bond on the robbery firearm pending that?
I would ask that it be kept at no bond until
it will remain no bond. This matter will be reset for 24 hours on the third unrelated criminal offense. In addition to that, the court is going to order no contact with the alleged victim of the aggravated assault with a deadly weapon. The alleged victim of the aggravated assault with a deadly weapon is one...
Your Honor? Well, no, I was just, before you state the name, I was going to make a request.
Okay.
Because I've provided Mr. Reedy with copies of all the affidavits. Mr. Reedy can certainly provide Mr. Romero with those names. I'm just
the pregnant woman that was with the decedent, he's to have no contact with that individual. Mr. Reedy, what would you like me to do?
I'm going to object to the state getting additional time, Judge. They've already had 48 hours to amend to perfect these documents. This case was originally heard on Sunday. And on Sunday, they were given 48 hours to this morning. Now they're getting additional 24 hours. That's beyond what's approved by statute. I think Mr. Romero has the statute right in front of him.
Your Honor, if I may respond. Judge Evans did not make any PC determination on any of the charges. When the state did not have the affidavit for the murder, he reset the entire matter without making any determination on any of the charges for 48 hours. This is the state's first opportunity to make a request for additional time.
Go ahead, counsel.
Judge, respectfully, everything at magistrate is governed by procedure. Pursuant to 3.133, the only time, or one of the times the state's entitled to ask for additional time is when there's no finding of probable cause. At that time, from the time of his offense, a judge could grant 48 hours, but from the time of his arrest, 48 hours already passed. If you want to go beyond the 48 hours, you must showing a good cause. But that's for probable cause. At this time, Your Honor already found probable cause. What they're asking for is additional time to get information for proof evident presumption great. There's nothing in the statute, and everything is governed by statute, to give the state an additional time to remedy the lack of I guess, evidence that they presented at this time for proof evidence.
Is it 48 hours from the time of arrest, or is it?
Correct.
It's 48
hours from the time of the arrest, and then after that, with good cause, you can extend it 24 hours.
And how far into this are we? And how far into this are we?
If we have the PC affidavit to see what time he was arrested.
Your Honor, the issue is that Judge Evans.
Counsel, I understand your issue. Just answer my question first, and then we'll go from there. When was he booked into the custody of the Sheriff of Broward County?
7 p.m. August 19th.
And today is?
The 22nd.
So that means that he has a right within 48 hours to be in front of a magistrate. He has been in front of a magistrate in that 48-hour period, realistically.
Yes.
All right. The judge reset this matter, which is putting us at roughly, at this point, 65 hours. So I guess the legal question is it 48 hours from the moment of arrest or 48 hours from the next possible magistrate hearing?
Probable cause determination is to be made within 48 hours from the time of arrest, and the state is entitled to 24 hours if PC is not found, or what I would argue, the state doesn't meet its legal burden. In this instance, it's proof evident or presumption great. Then,
is it the Office of the Public Defender's position that you have 72 hours for probable cause in the light most favorable to the state, but you don't have 72 hours for proof evident presumption great? Is that what you're saying?
Yes, Judge. I don't see anywhere in the statute where it allows for that reason.
So your legal argument, I just want to make sure I understand your position clearly, is the statute allows 48 hours for probable cause and an additional 24 hours to perfect probable cause. We all agree on that.
From the time of the arrest, correct.
All right. Your position is that because the statute allows 24 additional hours specifically for probable cause and it doesn't delineate for proof evident presumption great, they shouldn't get the additional 24 hours.
That's one of my arguments, correct.
All right, well, that one's not going to work. What other arguments do you have?
I believe they're already past their 72 hours, Judge. If he was arrested on the 19th and today's the 22nd, I've never been good at math, I believe 72 hours is already passed.
That's okay.
All right, State.
Your Honor, my understanding of the rule is probable cause to be made, determination is to be made within 48 hours. If it is not found or whatever burden the state has, the state may request 24 hours. If it can't be perfected within 24 hours, the state may, on a showing of cause, ask for an additional 24 hours. I am asking for that additional 24 hours, and my argument for cause is that Judge Evans didn't make a probable cause determination.
So in other words, and you're not denigrating Judge Evans, but you weren't aware that you were in this dilemma until we were into the 72-hour point.
There was no objection made by the defense that I could respond to.
Mr. Bynum, we'll see you back tomorrow morning for a probable cause determination. The Office of the Public Defender's objections are noted. And in light of the fact that a judge of this circuit did not make a determination, I think that is a legal basis for the state to ask for an additional 24 hours in light of the grievousness of the charge, in light of the proof evident presumption great that he committed a first-degree murder. I'm giving him 24 hours. All right? Anything?
Judge, and one last thing, I apologize.
Yeah, whatever you want. We're dealing with a big issue here. Go ahead.
Judge, it says, as far as good cause, just to get additional information, no matter what the charge is, I don't think it rises at this point to good cause. I believe good cause would be, Judge, we've been in contact with the detective. Unfortunately, at this time, he's assigned to another, he's handling some emergency. We haven't had the opportunity to fully talk to him. Here, they're just asking for more time, just for the sake of asking for more time, because they are. But I don't think at this time it rises to the level of good cause.
One of the things that I have to do, and one of the obligations that I and my 89 peers in this circuit has, is to hold ourselves accountable for our mistakes or errors that we make as judges. I'm not saying Judge Evans made a mistake, but what I am saying is Judge Evans did not put the state on notice, the Office of the Public Defender did not put the state on notice of the fact that they had one specific concern. That is being raised for the first time today based upon the fact that Judge Evans did not make a finding yesterday. I think that but for the judge's decision to roll this for 24 hours, we would have met, or 48 hours, we would have met the deadline. So I find that to be good reason. It's not the state's fault we're here again, at least not to my knowledge from what I've heard. It's because the judge in an abundance of caution was protecting your client's rights. We'll see you tomorrow morning. Anything else on this?
Nothing.
We'll see you this afternoon, Judge.
I look forward to it. Court will be in recess.